Welcome back to #Lawyer. Today we've got Criminal Defense 101, from arrest and bail proceedings to plea negotiation and what actually goes on your record, giving you the information you need to know how the criminal defense system works. Guys, welcome back to #Lawyer. You've got the A-team here, Andrea and Austin. Andrea came up with that coin term. I kind of like it now, so I'm probably going to keep using it.
You are so welcome, Austin. Always here to provide.
Well, I appreciate it. Well, so today we've got a general overview subject that I think is extremely important. And what's funny is anytime I'm talking about criminal defense, I always tell people, you're probably never going to need this, but
fingers crossed.
Your friends might. Or the other part is it's just good for people to understand how the system works, because Law and Order and crime podcasts and all sorts of things, they're entertaining and a lot of them have good information, but a lot of the nitty gritty of what actually goes on outside of trial and outside of the drama, people don't really understand that. And it really shades their perception of people who are accused of crimes, how efficient the system is or is not. I'll share my opinions about that here in a little bit.
Can't wait.
Right. And just, I think it's really good information for our listeners to have, because it really is practical.
Absolutely.
On how the policy goes. And so really what we're going to do is we're not going to get into anything that, like, how to present evidence or specifics of trial.
That's too much.
We're not going to get into all that. And actually, we're not really even going to talk about trial much in this episode. I'm wanting to focus on what happens when you get arrested, how bail works, how the plea bargain process works, because that's the part that's completely foreign to most people.
And controversial to some people, too.
It is, especially to me. So you get to hear some of that here in a little bit.
And my dad.
Well, and then a big question that we get asked all the time is, how will this affect my record, my future, my employment? How does this work? And that's something we're going to spend quite a bit of time discussing here. So let's just kind of jump right in. And the other part of this, we're focused on Texas law. That's where we air from, and that's kind of the area that we know. A lot of states are similar, maybe different, but the procedures that we're going to talk about here are specific to Texas.
Yeah, and that's at the state level, not the federal level. Federal is a whole different beast. I mean, one big criminal case I did was at the federal level, and the FBI was involved, and that was really different than a state courtroom.
Yeah, it absolutely is. And there's honestly, 9 times out of 10 when you're dealing with with criminal cases, they're typically going to be state cases. So I feel like that probably helps our listeners out, a little more. So first off, let's just talk about getting arrested. And we're not going to talk about what led up to it, but you've been arrested. And so, the definition,
me.
Well, not you, excuse me. Your friend has been arrested. We'll go back to that analogy.
Okay.
What is the definition of being arrested in layman's terms?
Right. So basically, you are detained, the handcuffs are thrown on you, and you are not permitted to leave the scene. You are there with the police officer, and you can't leave. Yeah.
Yeah. And that's the simplest definition. It's actually the one that's been held up most times. There's some distinctions and some discussions about when you say certain things, when you don't say certain things, whether it's pre-arrest, post-arrest. And that actually brings up one of the biggest misconceptions that TV has blown out of proportion.
Yes.
And that's your Miranda Rights.
Miranda Rights.
Now, what are those? Let's go into that first.
Sure. So I think everyone has heard of Miranda Rights. Y'all know the scenes from Law and Order, right? Or I guess not really defending Jacob because it doesn't show up in there.
Right.
Which is a great TV show, by the way. It's actually kind of sort of accurate. Anyway, but that's Northeastern law, not Texas law. Miranda rights are where you are, after you're arrested, right? You are read your rights. You have the right to remain silent. Everything you can say, can be used against you in a court of law, so on and so forth.
Yeah. Okay. And those were put in place to protect against what?
That was put into place to protect you from violating your Fifth Amendment rights, right? So protecting you from incriminating yourself, and also is going to protect you from giving a coerced confession, right? So if the cops are staring you down, they're like, we have the bloody gun, we have the knife, we have the poisoning instrument, we know you did it, we know you did it, John Doe. And then John Doe's like, oh no, I did it, even though it was his brother who did it. And he confesses and then put in jail, and oh no, death penalty. No, we're not going to go into that.
Yeah, but the analogy, exactly, because over the course of our history, there were times where people were not tortured, but they were put into a room for 9 hours without food. They were drilled over and over again, and just all sorts of stuff. And so the Supreme Court said that you have to tell somebody they have the right to remain silent, that they don't have to talk to you, and you have to inform them that they have the right to a lawyer to help prevent these things from occurring. Now, the biggest misconception about this, and this happens a lot of times when people come to my office, is they say, they arrested me, they didn't read me my Miranda rights, so we're good, right? Like the case is going to get tossed. It's not how that works.
No, it's not.
Because, and here's the deal, and I think actually, we discussed a little bit before coming on air about defending Jacob. And I think that's a great analogy to demonstrate how that actually does protect somebody.
Sure. So let's set the scene, right? So I watched Defending Jacob with my husband the other night, and it's actually really, really good. And so there is the scene, spoiler alert. Okay, you can keep listening or not, fast forward if you don't want to hear it. But I think it's kind of obvious. Okay, Jacob is the son of a local DA, and he is accused of murdering a classmate. So he goes missing. There's this big manhunt for him, and a female cop finds him on a swing at a playground. So she does not read him his Miranda rights. She, I'm pretty sure, puts his handcuffs on and says, get in the squad car. There's a lot of people looking for you, and pops him into the squad car. So she's driving to the police station, and about a few minutes into it, Jacob starts talking. And he says, Jacob's the little boy who's accused of murder. And he says, I didn't do it. I found my classmate there. I thought he was hurt, so I leaned over and rolled him over by his collar, and I saw the blood and knew he was dead, freaked out and ran away. Okay, well, if he had confessed instead of just saying, I didn't do it, now we're in a situation where if he wasn't read his Miranda rights and he confessed after being arrested, that would be a problem, wouldn't it?
It would most likely be a problem. Yeah, and there's always gray area in the law, but most likely at that point, he's confessed without knowing his rights. Therefore, that's a confession that's been obtained illegally because he doesn't know, I don't have to talk to you. Exactly. I can get a lawyer. Now, juxtapose that with the number one case that I get asked this question all the time is DWI.
Yeah.
Person gets arrested, and I will delve into the specifics of this because in Texas, once you are arrested for a DWI, they then read you this warning that warns you about how your driver's license can be suspended and all these types of things. Legally, they don't have to Mirandize you. And by the way, when we say Mirandize, that's the verb of giving you the Miranda warning, reading your rights, Mirandize, same
us
thing.
lawyers, we've created our own verbs. Woo.
Well, the word sounds fancier, So, but that's a situation where they don't have to read you your Miranda rights. They can legally read you that statutory warning. And then it really doesn't matter because in that and like drug cases and things, typically they've already obtained the evidence against you.
Sure.
They saw you driving drunk. They found the cocaine. They don't need you to confess to anything because they got you. And so it really doesn't matter that you didn't have your Miranda rights read to you. So sorry, everybody. Doesn't necessarily matter. That's not the get out of jail free card. Unfortunately, you got to delve a little deeper into it. Now,
absolutely. Back
to the procedure. And this is one that bail and how bail is treated is something that a lot of people don't understand. And unfortunately, there's a lot of the control in the bail system is taken out of the hands of the lawyers and actually is really in the county jail's control. They kind of set the policies for it.
Interesting.
And it differs county to county. So constitutionally, with the exception of certain offenses and certain situations, you are entitled to have a bail set. That's something that's in the Bill of Rights. It's in state constitutions, and it's because you can't be held without bail. That was one of the problems we had back when we were colonies and Great Britain was ruling over us. Yeah.
Also, so just for those people who maybe don't watch Law and Order, or what is bail?
Yeah. Well, right. Well, and so there's two terms. There's bail and there's bond.
Okay.
Now, in slang conversation, we kind of use them interchangeably.
Sure.
Basically, what bail is you are arrested and they have charged you with they've accused you of some certain crime. And you either the purpose of bail is you pay down a certain amount of money and they let you out of jail while you await your trial or await the next steps, which we'll get to in a second. And the purpose is that it ensures that you will show back up to court and face these charges. Because if you don't show back up, if you skip bail, that's what they call it, when you don't show up or you do something, then you forfeit that money. State keeps it and it goes into registry somewhere down the line.
So do you get your money back then if you do show up?
So yes, on bail. And so that kind of segues into what bond is.
Okay.
So everybody's heard of using bondsmen. And typically,
I see them in South Dallas sometimes.
There you go. Right. And so typically you've got bail, and let's say you're arrested for, let's just call it possession of a controlled substance.
John Doe, at it again. Gosh, Johnny boy. Oof.
He's out there slinging coke. He's running around. And let's say because he's slinging coke, he's got a lot on him. So we're not just talking about a couple ounces or grams. We're looking like we're manufacturing.
He's got a whole freaking like Birkin bag full, a knockoff Birkin bag full of coke.
Well, let's make it better. The bag was found sewn into the bottom of his Astro van. So it's in a compartment. So he's got a lot. He's got quite a few kilos. So let's say his bail is set at $100,000. So what he can do is if he's got 100 G's, he can put that down.
Okay.
It'll go into the registry of the court, and then they will let him out.
Okay.
And then eventually, as the case goes on, whether he is found guilty, acquitted, it pleads out, whatever, once the case is over, he can apply and have that money given back to him. So that 100 grand comes back out. There's usually some administrative fees that come out of that, but he gets the cash back.
For the most part.
For the most part. Problem is most people don't have that kind of money lying around.
Sure.
So what you can do is use a bondsman. Typically, a bondsman requires you pay them 10% of what that bail is. Okay. So they can make a bond. They then vouch for the remaining 90%, and then you are let out of jail under the bondsman's purview, so to speak. Now, the difference with a bond is you don't get that 10% back.
It is gone.
That's the fee to the bondsman because they're putting their neck on the line for you. Because if you skip, they got to put up the rest of that money. And then you ever heard of Dog Bounty Hunter?
Of course,
that's what he's bounty hunting. Is that whenever people skip bond, he goes after them, takes them back in, and gets them back to jail so he can get his money back.
I feel so enlightened now. I thought he was just searching FBI's most wanted or whatever.
Right? No, he doesn't have that much power. He's just trying to get his cash back. So yeah, that's what bail. That's what bail and bond is. And the problem is we won't get into all we'll get into some of my personal opinions.
I was about to say, please entertain us.
There was a federal lawsuit filed a couple years ago by the ACLU challenging, and they've been doing it in a lot of counties across Texas and across the country, challenging the unconstitutionality of how bail has been used in this country. Bail's purpose is ensure that people show up and make sure that we are protecting the public. Well, bail in most places is set based on two factors. What have you been accused of? And what is their criminal history? Okay. On the surface, that sounds like, okay, well, if they've been accused of a dangerous crime, okay, well, maybe that protects the safety. But at the same time, they haven't done any analysis into, okay, can this person afford this? Can they get out? Are they actually a danger to the public, or are we just assuming by what they've been charged with that they are?
Well, what about flight risk? Isn't that something people hear all the time? Like, if you're a flight risk.
It is, but they don't factor that in as much as the other factors. And that should be factored in more. Yeah. And so what we had in Dallas County, I'm going to take two extreme examples, but you have the serial domestic abuse defendant this is his third time in jail for beating up someone within his household, for assaulting them.
I like this guy.
But he makes a lot of money. And I'm sorry I'm saying he, but that's just,
statistically, that is what generally it is.
He makes a lot of money. He can put down the 250 grand bail or the 25,000 to pay a bondsman and get out. Versus you have the low income person who's arrested for marijuana possession. They can't make bail because they don't have money. And then now they're stuck in jail awaiting their trial. They're going to lose their job because they can't afford to get bailed out. And it was marijuana possession, which is a non-violent, victimless crime. Yeah. And so you can see the unfairness there. So there's been a lot of reform. Good news is if your bail is set at a level that you believe is too high, or if they don't set you bail, your defense lawyer can file a motion to have bail set at a more reasonable rate and try to get you out of there based on income factors and a bunch of other things like that.
But in the meantime, you're sitting in a jail cell.
You are. Until you get bail, you are in custody.
And how long does that take if you say, I want my lawyer to file these motions to try and reduce my bail?
Usually in non-COVID times, normally you can get in front of a judge very quickly.
Very quickly? How fast is that?
24, 48 hours.
Oh, okay. So it is quicker than I thought.
It's considered a habeas corpus, which is an emergency motion. Basically, it says, show me the body, bring me the person, because
it's Latin, y'all.
Yeah, you're violating your constitutional rights by keeping them in custody without setting bail. It's back to those fundamental rights we were talking about before. So the other important part about bail is that if you violate, there's certain terms of bail when you are let out. Bail bond. Again, we're going to interchange those terms. So typically, let's go with a DWI. Sure. You've been arrested for DWI. Part of your bail requirements typically are going to require you have an interlock deep lung device on your car for certain DWI offenses, most of them these days, which means that you have to blow into it before you start your vehicle.
Blow before you drive.
Right. And your bond conditions say that you can't, what I call light up your device. You can't violate it, can't register that you have alcohol in your system. So you could put down your $1,000 for your, to your bondsman. They let you out because you have a $10,000 bail. You get the deep lung device put in your car. 3 weeks later, you're drunk and you blow into the deep lung device. It registers, sends that back to the probation office. And then the court's going to file a motion to revoke your bond and say you violated the terms. Guess what? You lose that bond. Now you owe the court $10,000. And oh, by the way, if you want to get back out, you got to put up another $5,000. So that's the other part of it, is that people don't realize, okay, now I'm out, I'm good. Well, okay, you've got to follow the rules once you're out, and they've got kind of a magnifying glass on you, and you could lose that money if you don't follow and play by the rules while the case is going on.
So I have a question. So when I was in my criminal case, right, it was, granted this was at the federal level, not state, because it was involved healthcare fraud.
Right.
And so when it came time to sentencing, I remember the judge looking at my defendant and then the other defendant that was there in the room saying that, y'all, we're moving on to sentencing. The trial is done. You've been found guilty. But so I guess this is a different scenario. Never mind.
Versus the bond. Yeah, you kind
versus the bond. Yeah. I was thinking probation because she told them after they had been found guilty, at least a couple of offenses, she was saying that there's some time before sentencing. You guys can go home. You're not being put into jumpsuits and taken to jail right now. But she's like, don't you dare so much as speed, because if you do, I'm throwing you in jail.
So actually, no. So it was before the sentencing hearing. That is actually still while they're on bail.
Okay.
Because at that point, the case isn't completely over yet. And so conditions of bail are still set right there.
So
no, you're absolutely correct.
Okay, well,
and it does function similar to probation. It's kind of like you're on a mini probation, honestly, because you're being monitored, you've got restrictions and all those kinds of things. So another interesting thing that people should know is here in Texas, you can file or you can have your defense lawyer put down what's called an attorney writ bond on certain minor offenses like a DWI, which is a Class B misdemeanor. And what that means is basically we can show up to the jail, show our bar card, show our driver's license. Typically $500 is what the cost is. And if someone has that money, they can put it down and the person can be released to the lawyer, basically on the lawyer's word that they're going to show back up.
Okay, how often does that happen? Because, let's be real. I love to be generous. But man, I really like my reputation as a lawyer, and I really like judges knowing that I'm good on my word.
Yeah,
I don't want someone messing that up for me.
So I've done it quite a bit. I've done it quite a bit because you bail the client out, and then you're on the hook for making sure they show up in court. You're not on the hook for the bail part of the bond or the money. Actually, one of my funniest stories about that is I was out on a Saturday hanging out with some friends, kind of doing some bar hopping, and a friend called and said, hey, my friend's been arrested, DWI last night. This is a Saturday. And I was like, well, look, I've had a beer or two. Like, I'm not driving. So I was like,
because you're smart.
He goes like, you can pick me up. And so person came, drove, picked me up at the bar I was at, drove me to McKinney. I put my bar card down. She put down the $500. They got out, and I was like, all right, take me back. So took me back and dropped me back off at the bar we were at, and we just kept going for the day. So
and the guy showed up, right?
Oh, the guy
problem?
showed up. Yeah, he ended up hiring us, and we represented him.
Oh, there you go.
It all worked out good. But so it can be that easy. I was wearing a backwards hat and shorts whenever I was going.
Oh my gosh!
So, hey, you got to work on the weekends sometimes, But that's the thing about bail is that you're entitled to it. It can be reduced if it's unreasonable, but you got to follow the rules or you're going to lose your money. And that also hurts you in the next phase if you mess up the bail for your plea negotiation, which is the next phase of all this.
Okay, so far the takeaway is you got to pay to play, but make sure you play right so you can get your money back.
Well said. Okay. That's exactly well said.
All right.
For sure. Now, eventually you're going to be charged with a crime. Now, there's two distinctions here, and people get this confused. You can be arrested for one thing and then charged for something else. So the reason for that is, the police make their arrest based on what they see, but then the district attorney is the one who ends up charging you with your crime or at least accusing you and moving forward with it. And so that they can look at what happened and say, well, this actually fits into this category as opposed to this category that the officer, alleged. And then at that point, we've got a decision of whether we're going to be pursuing a misdemeanor or a felony.
Sure.
Yeah. And so, there's a difference there in how that starts. And I know, we hear this word indictment thrown around all the time. You kind of explain to everybody what that really means.
Absolutely. So an indictment is a unique animal. So basically what an indictment is so you're accused of a crime, you've been arrested.
Felony.
More
serious crime.
Thank you. Yes. So you've been arrested for a serious crime. For example, possession of 1,000 kilos of cocaine. Let's just make it egregious. Right. And so it's pretty bad.
Yeah, I mean, sexual assault, robbery, murder, all those things.
Yeah. So in order for you to proceed to an actual trial, right, you have to get past the indictment stage. So an indictment is where the prosecutor brings you in front of a grand jury, and that's 9 to 12 people, at least 9, no less. And evidence is put on, testimony is put on, and then the grand jury, and this is all done in secret.
Yep.
And the grand jury, after hearing and listening and weighing all of the evidence and all of the testimony, decides whether or not there's enough evidence to proceed to an actual criminal trial on the matters. And so if the grand jury finds that there is enough evidence, they'll issue what's called a true bill here in the state of Texas, which means there is enough evidence of your sexual assault, John Doe, you're going to trial. Or they say no bill, which is John Doe, there is not enough evidence in our collective mind as a grand jury. This isn't going to trial, and that's the end of the story.
Right. And then at that point, if the grand jury issues a true bill, then the prosecutor gets to formally file the case against you, and then we open up that plea bargain process, which we're going to get into in a second.
I think something to note, too, is that grand jury is cloaked in secrecy and mystery. And a lot of people actually find that really upsetting. But at the end of the day, it's really for, that person's benefit, because if there isn't enough evidence against them, like, why would they want this smeared all over social media and all over the news? Like, if you were accused of, massive amounts of cocaine possession, but there simply isn't enough evidence and you didn't do it, why would you want that out in the world?
Right.
It's a false accusation.
Yeah, and you want that's very true. And then you want the grand jurors to feel like they can be honest with what they're deciding.
Absolutely, and you don't want them to have any pressure. And so it's really important that this is conducted in secrecy, and it's been that way since the beginning of the judicial system.
Right.
At least here in the U.S.
Right. So, and depending on what county you're in, it can take a while between your arrest and the grand jury actually looking at your case. I mean, in some situations, especially with drug cases where they've got to send it off to the lab, and they have to get the lab results back before they can present to the grand jury. In Dallas County, you're looking at potentially 4 or 5 months between when you've been arrested and the grand jury even looks at your case. And so that's a misconception. A lot of people assume okay, we're going to get after this, and no, you don't really do that.
And I also want to go back to the secrecy moment. So say that someone is given a true bill, they're your client. Do you get access to what the grand jury looked at, the evidence and the testimony and things like that?
You don't.
Even as the defense attorney?
Even as the defense lawyer. They don't even allow me in the room. So
crazy, right?
Right. Like we can write letters and submit what we call a grand jury packet to try and persuade the grand jury. And that is presented, albeit it's presented by the state. So I don't know how persuasive they are when they show them the evidence.
I'll ask Tara.
Yeah, there you go. But we are allowed to present that. And one distinction I do want to point out before we move on is, for a felony, you have to be indicted by a grand jury. It means that 9 of your peers have to say, look, there's enough evidence here that, you should go ahead and charge that person with the crime. For a misdemeanor, less serious crime, weed possession, DWI, criminal trespass, the prosecutor can file what's called an information, which basically means the prosecutor doesn't have to go to a grand jury. They can just decide on their own accord, there's enough here to go forward and charge this person. So because it's a less serious crime, there's less requirements that allow the case to proceed forward. And so once you are formally charged, felony indictment, misdemeanor information, now we start the plea negotiation process. And this is probably the biggest misconception, the biggest stage where there are misconceptions because of all the different things that factor into this. And the overall picture is you really are in somewhat of like a contractual negotiation with the state's attorney and the defense lawyer, trying to figure out, okay, the state's going to make an offer. Do we want to accept it? How does this work? And this is the part where some of my views come into play, is that the entirety of the leverage is on the state side in this process. They don't have to actually offer a plea offer to the person accused of crime.
Common misconception. They don't have to, and there's a lot of big cases where they don't offer it. Capital cases, there's sometimes where they say, we're not offering. Capital is in.
Oh, sorry, capital murder, right. So death penalty cases. They say, look, this crime is so egregious, we're not offering a plea. we're going to trial. We're going for the death penalty. Just gear up and we're doing
Which
it.
is still allowed in Texas, by the way.
Still allowed in Texas. And so there's a lot of times with that, I mean, they're not constitutionally required to offer a plea. Now, when you enter into this process, there are 3 possible outcomes at the end of this criminal case. You either have a defendant plead guilty to something, you have a case dismissed, if and we'll get into that in a second, or you end up going to trial. And there's no other 3 options.
That's it.
I mean, and there's some things, there's pretrial diversion programs and things that I couch those in terms of either a dismissal or a plea, where people can do these programs that maybe help them go through a 2-year rehabilitation plan.
I was about to say, what's a quick example?
Yeah, so go through a 2-year rehabilitation plan with classes and things like that for drug charges. And then the case eventually gets dismissed. That still falls under the dismissal category. But there's not some third magical or fourth magical deal. It's plea, dismiss, trial.
So the concept of drug courts would fall into the dismissal category eventually.
Right, exactly. It's a pretrial thing to try to keep people from having something, on their record. And so, again, the state, the leverage is completely on the state. And so eventually, after you've been charged, you're going to have a first appearance that you have to show up for court for. And there's some counties where they allow the lawyer to show up and the defendant doesn't have to, but most counties, you're going to have to make an appearance with your defense lawyer, show up to court. You've got a court date, 9 a.m. on Monday the 31st. Now, TV, podcast, everything.
Yes.
What do most people expect their first day in court to be, Andrea?
Woo, right? Everyone thinks that you show up, you're in your suit, you have your attorneys flanking you, you maybe already have the pool from which you select your jury lining up outside the halls. And it's like you are ready to put on evidence and go to court and prove your innocence. Okay, that's nothing at all when it actually is like normally, right? What happens? You show up. And honestly, the prosecutor probably hasn't even looked at your client's case yet. Not even looked. They're like, who is this person?
And so you're basically, I'm saying, hey, my name's Austin. I'm the defense lawyer. I filed my letter showing, can I have the case file? And they hand it over and then they say, all right, get your next court date. And it's typically a 5-minute conversation at that point. And that's upsetting to some people because they're like, well, why haven't they looked at my case? And honestly, the thing is, prosecutors have hundreds, some people, multiple hundreds of cases on their desk that they're looking at.
Really busy people.
And they're working through everything. And quite honestly, you're just a number to them at that point.
And so, at this point, let's make this really clear. Do you even get to appear before the judge at this point on your first appearance?
Most of the time, not. So there's some counties where they want to have, in felony cases, they want to bring the client forward and formally arraign them, which means just tell them you've formally been charged on the record with this case. And that sometimes happens, but it's more of a formality than anything, honestly. Typically, you're showing up, it's a 5 to 15-minute situation, and then you're getting a new court date 3, 4, 6 weeks later. And during that time, your defense lawyer is going to look at your case file, look at the police report. A good thing is that we have laws in this state and in this country that require the state's lawyers to turn over every shred of evidence they have. So we don't have to file any kind of motions or anything like that. By law, they give it to us, so we get to see the body cams, the evidence. Everything. We get to see everything. And so
pictures of the bloody knife.
Right, exactly.
Karen defending Jacob.
Exactly.
Even though they didn't find the knife.
And this is what I always tell my clients during this process. It's a negotiation, and it's to be completely honest, you can get better deals in certain counties. Some counties are stricter on certain crimes than others, and so it really does matter where you are arrested. And I won't go into specifics while we're on the podcast.
Yeah, probably not a good idea.
But any defense lawyers listening to me know what counties are. It's going to be a little more rough whenever you've got certain charges, and that's just you learn that from the business. The ultimate thing, what I tell my clients is what we're trying to do is. We're trying to negotiate down the best potential plea that you could receive from the state so that at the end of this, we have to make a decision ultimately that says, okay, I'm going to accept this plea or I'm going to go to trial.
Yep.
If we don't have this plea down as low as it can possibly go, then you're comparing apples and oranges here because you could potentially have a lower plea and you may be taking some unnecessary risk. And that risk I'm talking about, some people think, well, what do you mean risk? Like, why would you just plead guilty if, you think you've got a decent case? Well, let's take.
You mean not guilty?
No, I'm saying why would you plead guilty if you think you have a decent? If you think you have a chance of potentially winning, right?
Gotcha.
And let's just take a DWI because it's easy to wrap your mind around. Let's say we get a plea deal down to you've got 15 months probation with all these terms, and then you're comparing that with okay, well, I may have to plead guilty, take 15 months probation, or there's some things that we have going in our favor. I think we have a decent shot at winning the case, but we could lose. Well, over here, you're facing up to 2 years in jail. And so you're risking more at this point. And so that's where people's motivation of, okay, well, do I take the plea or do I go to trial? And you've got to have a good lawyer there to sit there and talk through, this is what I think is strong, this is what's weak, this is the risk we're taking, so that you can make an educated decision. But, say that you didn't get that plea down to 15 months, say they're looking at 24 months or 30 months. Well, at that point, you're not really comparing the two similar products to each other, and you're not making a really informed decision. Now again, I've had to have many tough conversations with people where they say, well, I don't understand, why won't they go down any further? I'm like, I'll tell you why they won't, but here's the problem. And they're like, why can't you make them? Because I can't. I mean, there's some things we can do, and I'm not trying to cop out totally, but you get to a certain point where the state's attorney, who has all the leverage in the plea negotiation, just says, I'm not going any lower, either accept it or we're going to trial. And that's your two choices, and that's the common misconception that people have is that there's more bargaining power on both sides, and there's really not, and that's part of my frustration with the plea process, because there should be a more level playing field because of how we're affecting people's future. You guys can follow that on my own Instagram page and the things I put out there. But that's kind of how the plea process works. And then at the end of it, you decide that you're either going to plea or go to trial. And that's the decision you end up making. Now, how does this affect me going forward? Not me, but
I was about to say, Austin, tell me all your feelings about this.
But how does this criminal offense that you've been accused of, how does it affect your record, your future employment? You're going to end up with one of four outcomes at the end of this entire process. Plea process, we have a couple decision trees. At the end of the entire thing, you're going to either be convicted, you're going to be found, you're going to take a deferred plea, or be given deferred adjudication, which we'll get to that in a second. The case is going to be dismissed, or you're going to be acquitted and found not guilty. It's going to be one of those outcomes. Now, Andrea, I'm going to ask you a personal question. Have you ever gotten a speeding ticket before?
Austin.
Come on.
Yes, and I will tell you the story. Highland Park. Guys. Be mindful of school zones in Highland Park. Okay, if I recall correctly, the school zone speeding situation, I think, starts at like 8:30 a.m. Okay, that's when the school zone kicks in. Normally it's 30 miles per hour. When the school zone kicks in, it's 20 miles per hour.
Right.
Okay. I was driving to the dentist, and I was, of course, running late. And so I was driving 31 miles per hour, I think, because I was like, okay, if I go one over, it's probably fine. I get pulled over, and I'm like, what? It's like before 8 a.m.
in the school zone.
Before 8 a.m. He pulls over, and he's like, so on and so forth. And what it boiled down to was it was 8:02 a.m. I was doing 31 miles per hour when the speed limit had dropped to 20 for the school zone. So I was speeding in a school zone, and I had just entered it by about 2 minutes.
So
I was very unhappy.
At the end of that, did they offer you some type of deferred adjudication?
Yes, I did.
And so you had to just basically go 90 days without getting another ticket, and
I took a online driver's ed course, and then I had to send in the certification and proof that I had finished the course, and I had done all the testing for it, and sent that in, and it was gone.
Yeah, and the ticket goes away.
Yeah.
Okay, so that same concept applies to any and all criminal offenses that you can be charged with. A little more restrictions, a little longer time period, but same idea. You can plead guilty, but get a deferred plea of guilty, which means that you complete probation, you do all these things, and then the conviction itself is going to fall off, and you're not convicted guilty of that. It just shows up that you took a deferred plea. Now, but why does that matter? So some people have heard of these terms, expunction and non-disclosure. What these two terms mean, and we're going to delve into it. This deals with how does a criminal charge show up on your record later on. So what do you have to say to employers? What can people see about your background? All that kind of stuff, which is most of the time that's people's second biggest concern when they're dealing with this. First biggest is, am I going to go to jail? But second biggest is, what is this going to look like in the future, right? So let's talk about an expunction first.
Okay.
An expunction is the ultimate dry erase board. It erases the arrest, the charge, any record that you had ever gone through this situation is wiped away. That's what everybody wants.
Always?
Right? Always.
Even if you say, hey, I'm applying to be a kindergarten teacher.
Correct. Always.
Wow.
Always. Because there's only certain situations where you can get an expunction. Either a dismissal or a not guilty verdict.
Gotcha.
So it's there for people who maybe were wrongfully accused or they're not proven innocent, but they're not found guilty. Or the case is
which
dismissed.
is an important distinction.
It is, absolutely. And so an acquittal is only eligible if the case is completely dismissed or you're found not guilty.
Okay.
And so then, your lawyer can file something, and then law enforcement can't see it. Licensing agencies like the Texas,
Texas Teachers Association. I don't know if that's not their name. Y'all know who I'm
Texas
talking
Board
about.
of Law Examiners.
There you go.
The medical board.
Yep.
That means that you don't have to disclose any of that on your application because it's been completely wiped away. But
which is a big deal, right?
It's a huge deal. Absolutely a huge deal, because you'll see the next part we're going to talk about is what's called a non-disclosure. There's a very complicated process that I'm not going to get into with all these limits and restrictions on what's eligible for it and what types of offenses are not. The main idea is that you can only get a non-disclosure if you take a deferred plea. So speeding
situation. Right. If I had done the whole 90 days probation and don't speed for 90 days, that would be an example of deferred action, yes?
It would be an example. Now, Class C misdemeanors are a different ballgame. You can actually get expunctions for those.
Oh, well, look at that.
So that's going to get into the weeds a little bit. But let's take a marijuana possession. That's kind of an easy one to talk about.
Never had that problem in my life, happy to say.
Class B misdemeanors, say that you take a deferred plea, you do your 1 year of probation or whatever it is, and then you successfully complete it. And now the conviction falls off your record, but it still shows on your record that you were charged and arrested and that you pled deferred to this marijuana charge. Well, because you pled deferred, you are eligible to have your lawyer file a petition for non-disclosure.
Okay.
If that's granted, and there's certain stipulations for when it can be filed and all that kind of stuff, but if that's granted, all private entities moving forward will not be able to see the record of your arrest, what you pled, any of those things.
So, for example, if you're Susie Q and you're applying to be a paralegal at an aviation law firm,
right?
If she's asked, "Have you ever had blah blah blah?"
Right. She can say no.
Okay.
She can say no.
And not get in trouble.
Okay. Because the background check they're going to run is not going to show it. Now, the distinction between that with an expunction is any licensing agency, any government authority.
Okay.
Police, federal agents, DPS, any licensing agency like, we were talking about teachers or lawyers, doctors, nurses, they will still be able to see it because they're a government agency. And so that's why everybody wants the expunction, but the expunction is only available for certain situations.
Okay.
Non-disclosure is the next best thing, but if you're applying to so actually, I'll tell you my story. I asked you about the speeding ticket. I'll tell you mine.
Oh, okay. Here we go.
At a party in 2007, I got a noise violation ticket for us having the music up too loud. And so
terrible, Austin. I don't know if I can associate with you anymore.
So when I applied to become a lawyer, I had to disclose, hey, look, had a party, got a noise violation ticket. Luckily, they still let me, take the bar exam. But that's the example of that licensing agency could see that on my record if they looked, which I'm sure they did.
The Texas Board of Law Examiners.
Texas Board of Law Examiners. So you have to disclose that and say, look, here it was. I pled deferred, got the deferred adjudication, but I do have to disclose it. So that's one of the big things that people want to know at the end of it. And so it's really important as people go through this to understand, all right, this is what the outcome is, and then this is what my options are moving forward, because it's completely dependent on what it is that you actually pled to, and unfortunately, those are the parameters that we have. And so there's a lot of times people are kind of boxed in during the plea negotiation process, and they have to pick something they maybe don't want to, and that's going to end up sticking with them because they can't fall into these categories. Yeah. But that's how it ends up, potentially affecting your future.
Okay, and I want to loop back around and ask you your thoughts, because I have actually had people tell me before that they think, and we're going to go back to the plea deal topic. I've had people come and tell me before, they're not lawyers, that they think that the concept of a plea deal is unconstitutional and that it's just morally wrong, and that these people are criminals, and why are you doing a criminal a favor and reducing their sentence, even if it's like a mafia mob boss situation and you have the driver ratting on the big boss and the driver gets a reduced sentence or gets off in order to get the mob boss. That's right. I've had people feel like that's just wrong. And I'm like,
Well, I can probably tell you those people have probably never had to go through the process themselves. They have a different
to my knowledge, they have never even gotten a speeding ticket.
Right. So it changes your perspective.
Yes.
I mean, you know me, I'm on the opposite end of the spectrum of that opinion. The justification and reason for it, it's not unconstitutional on either side.
Okay.
You know, even my argument earlier that I think that our process is broken.
Yeah.
It's not unconstitutional. It can be better. You know,
always room for improvement.
But the reason they do that, the same reason that defendants will accept a plea deal whenever maybe they have a shot at winning at trial, is because they don't want to risk it, right? It's the same thing on the opposite side of the spectrum too. The state will offer a plea deal so that they can delve out a certain amount of punishment for the crime that the person's been charged with, without having to devote state's resources to trying the case, preparing for trial, so they can use those resources to go after bigger fish, go after more serious crimes. And so it's better for state prosecutor to say, okay, look, I'm going to give this person 15 months for this DWI. Now those hours that I was going to use preparing for this trial, I can prepare now for this assault charge, which is much more important, and we need to punish this person more for public policy reasons. Yeah. So that's the reason they do it. Because if they tried every case, we wouldn't have time to try. I mean, we just wouldn't have time to do all
And
that.
It sounds like it's a pretty efficient use of our taxpayer dollars.
It is. Again, it can be better. There's a lot of things that
could be better.
The concept, the overall concept is an efficient use of our taxpayer dollars so that we're actually going after serious criminals that we need to keep off the streets. So, again, there's a lot of stuff that, I mean, you could tell there's a lot of stuff I wanted to get more into.
There's so much. And, but I think it would be really helpful too, like for some of our listeners to like DM us and let us know
100%.
like what areas of criminal law like they want to hear about, right?
Yeah.
You know, if they watched Defending Jacob, again, highly recommend it. I'm not promoting it's not an ad. I just really liked it.
Yeah.
Watch it and be like, I have a question about this part of the process or that part of the process or whatever. I mean, because there's so much to this area of law.
There is. And I'm glad you said that, because I really do want our listeners to DM us and ask us questions, because we went through a lot of this very quickly. And so you guys can tell we love talking about this stuff. And
a lot.
I want to be able to delve in and get more in depth about it when people want to know. And then there's definitely going to be some more specific things as we go through more episodes that we can jump into.
Absolutely.
So, well, guys, thank you for being here with us again on #Lawyer. Make sure and stay tuned for our closing arguments. We're going to talk about the recent shooting in Kenosha, Wisconsin of Jacob Brown and where we see this going and some things you need to be paying attention to.
Hey, y'all. Thank you so much for listening to #Lawyer today. But wait, before you go, we want to make sure that you know where to find us on all the socials. So catch up with us on the audiovisual portion on YouTube. We have a #Lawyer channel there that we're very excited for you to take a look at if you want to put some faces to names. I know I love doing that. Make sure to follow us on our Instagrams, whether it be the #Lawyered Instagram or Austin's and my personal Instagrams. We check all three, so make sure to DM us or frankly leave comments on all of our latest posts to make sure that we're covering the topics that you guys are interested in. And if you have any questions or you're like, hey, I heard this in the news today, I think it's really interesting. I kind of want you and Austin to break it down for me and give the legal perspective so that I am well equipped at my next dinner party or Zoom cocktail hour, COVID and all that, to be able to discuss this with my friends. So again, thank you so much for listening. Make sure to rate and review the podcast on whatever platform that you're listening to. And we are so thankful that you're listening, and tune back in next week. Bye, y'all.
Jacob Brown was shot 7 times in Kenosha, Wisconsin, and it's another story of a black man being gunned down by police. From witnesses that were at the scene, they saw that he was breaking up a domestic incident between 2 females, not involving himself, and police were called to the domestic scene. Mr. Brown's children and fiance were in his black SUV, and when the police showed up, they confronted him and a heated discussion ensued. At one point, Mr. Brown walked around the front of his SUV and was leaning into his vehicle and was shot 7 times at point-blank range in the back by the officers. Currently, Mr. Brown is hospitalized in Milwaukee and is suffering from paralysis, and they're not sure whether or not he's going to recover. At this point, we've seen that 2 days and nights of protests followed, prompting the governor to bring in the National Guard and issue a curfew. This is just another long line of shootings of black citizens where we're unclear as to why the police shot him, unclear as to what the facts were leading up to this, and we're going to continue to monitor this and encourage you to do the same.